The U.S. Supreme Court has agreed today to hear arguments in a major abortion case from Mississippi. The case surrounds a 2018 law passed to ban abortions after 15 weeks of pregnancy. It was blocked by lower courts for being inconsistent with a Supreme Court precedent. Here to talk more about this is CBS News legal contributor and professor at Loyola Law School, Jessica Levinson. Hi, Jessica. Welcome. So first, when can we expect the Supreme Court to take up this case? And what exactly are justices being asked to examine? Is this a very narrow examination over the viability status of a fetus?
No, I think this is a big challenge. So when are we expecting to hear it? I think they'll set it for oral arguments in the fall. The question will be if the Supreme Court is back in person for oral arguments, and I expect that they will be. And then we could have a decision. Frankly, it could take a year from now to actually get the decision, because there are still some cases from this term where they were argued in early November and we're still waiting on decisions. For instance, in the big Obamacare decision, the big Affordable Care Act case. Now, you asked me, is this a fairly narrow question? And the answer, I think, is no. This is a full kind of frontal assault, so to speak, dealing with the Supreme Court's abortion jurisprudence. And the reason that, as you said in the introduction, the reason that that the lower courts said, look, this Mississippi law isn't going into effect, is because it goes against the two big Supreme Court decisions that are still on the books from the court. And that being, of course, the 1973 decision in Roe versus Wade, and then that 1992 decision in Planned Parenthood versus Casey. And so if the court rules that this Mississippi law can be upheld, that would upend Roe, it would upend Casey, and that's another way of saying it would upend our abortion law cases as we know them. It would allow states throughout the country to implement much, much more restrictive laws.
But this will be a very difficult thing to do, correct? I mean, because you're talking about upending not just one, but two, but three, precedents, right? So what kind of argument will the side that's arguing to lower the threshold for having an abortion to 15 weeks, what kind of argument will they have to present that will be able to upend so much precedent?
Yeah, that's a great question. And we saw the court struggle with this issue in just last term, actually, where there was a law dealing with a Louisiana law dealing with whether doctors who perform abortions had to have admitting privileges. And the court said, we're not going to uphold that law. But they said it really only because they had just ruled that a similar law out of Texas in 2016 was unconstitutional, which is another way of addressing your question about precedent. And in that 2020 decision, the Chief Justice of the United States only joined with the liberals because he said, look, basically, we just made this decision, but it's not a matter of first impression. If it were a matter of first impression, then I would have upheld the law. And so those who are arguing against, you asked me, what are people going to say when they're going to argue against decades of Supreme Court jurisprudence? And I think what they'll say is it's time to re-examine that framework, that in fact, you have to evaluate it on a different basis, that the Casey case, that 1992 case, changed the standard a little bit from Roe versus Wade. And now they might argue, kind of due for another challenge. And I think what they might argue also, because this is a very different Supreme Court, this is a conservative 6-3 court, they may argue, look, Roe versus Wade and Casey versus Planned Parenthood, those decisions are just wrong. There is not a constitutionally protected right to obtain an abortion pre-viability. And so we could also see, again, just a clear and direct attack on those cases.
It's fascinating. And of course, like you pointed out, this is the first big dispute for former President Trump's 3 appointed justices. How could the balance of the court, not only influence the outcome of this case, but the entire 50 years of abortion rights we've seen in this country? I mean, is it dramatic to state that we could go back to where we were pre-1973?
I don't think it's dramatic to say that. I hope that I'm wrong and that, in fact, that is hyperbole. But if you look at the makeup of this court, I mean, let's remember every time there's a Supreme Court vacancy, people on both sides of the abortion debate, the first thing they think of is, what is this person's view on Roe? What is their view on abortion? We have a Supreme Court now where I think at least 6 members of the court, 3 of those appointed by former President Trump, are judges where if they got the Roe versus Wade case as a matter of first impression, if they were there in 1973, would have upheld much more restrictions and probably would not have found that there's a right to obtain an abortion in the Constitution. The question for the court, and this is the first big case with this Supreme Court to ask the question, is will you continue to adhere to that decades-old case? And if not, then what happens is, and I think it's important for people to know, if you live in a state where there are permissible abortion laws, meaning it's very comparatively easy to obtain access to an abortion, that doesn't mean that those laws are overturned. It means that this is up to each state. It means that if you live in a state where they want to implement very restrictive measures, then that could be newly constitutional. But I'm talking to you from Los Angeles. In California, we're not going to implement restrictive measures. And so the decision might not affect women in California in nearly the same way.
Right. All right. We could talk about this, the entire show, but I want to pivot to today's anniversary of another historic Supreme Court ruling, Brown versus the Board of Education. I pointed out just because it's another example of how consequential these Supreme Court rulings can be for generations to come.
Absolutely. This is why when I speak to my students about, do you think you're a single issue voter? I say, think about voting for the president who's going to appoint justices and judges who you agree with, because these decisions live far beyond any presidential term, live far beyond most senators' time in office. And the makeup of the Supreme Court and the makeup of the lower courts, the federal judges that make 90+% of the decisions, is incredibly important and affects our daily lives in deep ways. Of course, the Brown versus Board of Education decision, a landmark decision that really changed the way we treat race in our country, we treat access to education in our country. And if people know a few Supreme Court decisions, it tends to be Brown versus Board of Education. Again, another very controversial decision, which we now view very differently than we did at the time. Roe versus Wade, and then maybe Citizens United, obviously with very different implications. But they all show how important it is. The people who sit in those 9 chairs really can have an impact on our lives for decades to come.
So consequential. Jessica Levinson, as always, thank you so much for joining us. We so appreciate your insight.
Thank you.